And so many familiar faces in the room. Thank you so much for being here for this very important conversation. I think, like most of you, I believe that the First Amendment is the single most important provision in the Constitution. It's not just about journalists, but it's about all of us, all of our rights being protected. And to a very large degree, the American crises that we're experiencing, the First Amendment is at the soul of it. And there's probably no better person from Earl Chertoff to engage in a conversation than the Dean of the First Amendment himself. I hope you don't mind me calling you that, but anytime there's anything cited, it's always Floyd Abrams. And for over 50 years, you have been the advocate and helping us to understand the First Amendment and making sense of our rights as citizens. And so it's a real honor to have you in this series.
Thank you.
And it's a real honor to have my colleague, Merle Chertoff, who is a professor of law at Georgetown and who runs our Justice and Society program here at the Aspen Institute, leading this conversation. So we expect to learn a lot. Thank you.
Thank you.
Well, thank you so much, Dr. Motley, and I want to welcome everybody who's here today. I am really looking forward to our conversation with Floyd Abrams. If modern First Amendment history has been written in the last 90 years since the First Amendment was applied to the states, Floyd Abrams has been one of its greatest influencers for over half of that time. He is, to those of us who came of age as lawyers in the late 1970s and the early 1980s, you are a legend. At my law school, if anybody was interested in the First Amendment or media law, you vied to go to the Cahill firm because that is where Floyd Abrams was. But you got to Cahill more or less by fluke. You want to tell the story of how you came to be at the Cahill firm?
Sure. I was clerking for a federal judge in Wilmington, Delaware. And I asked him what law firms had been before you from New York in litigations that impressed you. And he wrote down for me the names of 5 law firms alphabetically. Cahill was the first on the list. At that time in my life, I didn't know what I wanted to do, but among the thoughts that I had was that I wasn't going to like it anyway, whatever firm I went to. And so I went for an interview, and they made me an offer. And I thought, well, that's terrific. I don't have to do the other ones. And so now it's 53 years. Chance plays a role in our lives. But that's how I got to Cahill.
So why did you decide to write The Soul of the First Amendment now?
Let me say first, it was not because of this president. I really did start it earlier. I wanted to put down in writing some of the things I found most interesting and too little talked about in the popular parlance and even amongst academics, how close we came to not having a Bill of Rights at all, for example. When the framers met in Philadelphia, they voted unanimously against a Bill of Rights. Every state that voted no on a Bill of Rights, for reasons we can go into. But I've always found that interesting, how different we are from other countries, which is what the core of the book is about, how much more protection we give. I've found through the years, whenever I give a speech abroad or go abroad and talk about First Amendment issues, that the journalists are shocked at how much freedom our journalists have as compared, and I'm not talking about Russia or Venezuela, I'm talking about England, Canada, free countries that simply strike a very different balance than we do about how to deal with the need to live in a free society and also one with certain limits of one sort or another that we can also talk about. And I thought I just wanted to mouth off a little bit about what I thought about WikiLeaks and Julian Assange and Snowden, not about the law, but my reactions to it. As I said earlier, it was sort of, it's my party and I can cry if I want to. It's my book, why don't I talk about something that interests me? So the last chapter is that.
Well, let's talk about the Pentagon Papers case. It's one of my earliest memories was the release of the Pentagon Papers, and it was a shocking and electrifying case at the time. Can you tell us a little bit about your experience on that case?
Sure. The Pentagon Papers, for any of you that don't have this right in the front of your minds, was a document that then Secretary of Defense Robert McNamara asked that the Defense Department, which he headed, prepare to deal with the issue of why we were in Vietnam. How did we come to be there? The Pentagon Papers dealt with the time period from the end of World War II through 1968, and was all based on Defense Department documents, virtually all of them classified top secret, and some of them deserving the classification of top secret. And what it basically showed was that there had been an awful lot of duplicity on the part of the U.S. government towards the U.S. public in explaining how we got in, how we slowly but ever so surely became involved, so that by the time the Pentagon Papers were done, we were in the midst of a full-fledged war, which resulted in the death of 50,000 Americans and hundreds and hundreds of thousands of Vietnamese, and yet had trouble answering the question, how did this all come to be? It's not that there were no justifications and arguments about being in Vietnam, but the background of it, how the policies were made, had been not very well revealed in the past. And so this 24-volume document was prepared, 7,000 pages. Now we deal in millions of pages, but I just want you to know that a leak of 7,000 pages in 1971 was not just the largest leak in American history, but a leak of such magnitude in number of pages. And let me say 3,000 pages were issues of the New York Times, all duly stamped top secret. But that's not all that was there. And so the Nixon administration was in power, and they had a decision to make about what to do about this. Henry Kissinger was then dealing secretly with China in what would later become our rapprochement with communist China. He in particular was very upset, told Nixon we would seem like a paper tiger if we couldn't keep this from happening. We can't keep secrets. And here he was in secret negotiations. Other people said to Nixon, this is all bad about Lyndon Johnson. You aren't even the villain of this one. In any event, John Mitchell, the Attorney General, advised Nixon, and the government went to court. And by purest chance, life, again, is funny, unpredictable, the Pentagon Papers began to be published on a Sunday, and by the papers I mean articles about them in the New York Times and some quotations from them. Monday, the next day, I hosted a lunch for media counsel who were working on a brief about confidential sources of journalists, which was a matter then before the Supreme Court. And I did it to introduce Alexander Bickel, a professor of at Yale Law School, professor of mine at Yale Law School, who was doing the draft of the amicus brief for the media entities, to introduce him to them. And at the lunch, Bickel and I were asked more than once, what do you think about the Times publishing the Pentagon Papers? And with what I've always thought was the great self-assurance of lawyers without clients, we said, no problem. The government's not going to, why would Nixon go to court? He doesn't even look bad in him. And we don't have prior restraints in America on the publication of news. We didn't know that the Times was lawyers, real lawyers for 60 years outside counsel. A firm of Lord Dan Lord had advised them that they would lose, that they'd be charged under the Espionage Act, that their television stations would, their licenses would be revoked, that the publisher might well go to jail. And here, Bickel and I were saying, no problem. And when the telegram came from John Mitchell, Attorney General, that night to the Times, and asked them, told them, hoped, in the current phrase, hoped that they would stop publishing. And the Times wrote back saying that they would not stop publishing, and the Times called their outside counsel. To their shock, they were told, we won't represent you. Herbert Brownell was their senior partner, former Attorney General under President Eisenhower, and we later learned from reading transcripts of Nixon tapes that the administration had asked Brownell not to let his law firm take this case. So the Times had no lawyer and had told the government they were going to continue to publish, and had Espionage Act prosecutions, very possible, indeed likely, against them. And one author later put it, they were like a vicar found in a house of ill repute at midnight without a lawyer. And they
But
thought,
you were comfortable in the house of ill repute.
But Bickel and I had seemed so sure that there was no problem and they'd win the case. And so they called us in the middle of the night. We went to the office, and the case took 15 days from the filing of the complaint through all the arguments and testimony in the district court, argument in the Court of Appeals, argument in the Supreme Court, and decision in the Supreme Court, all in 15 days. And then Professor Bickel went back to Yale, and I was suddenly, the words didn't exist then, a First Amendment, or how shall I say, the First Amendment lawyer, because we had done this great case. And that was sort of the beginning of my intense involvement.
So there's a straight line from the Pentagon Papers case to the WikiLeaks, Snowden, and Assange cases. And as you point out, now we're talking about millions of pages and really the crown jewels of national security. What do you think about the difference between the Pentagon Papers case and these cases? Well,
two things. First, there are no cases yet with WikiLeaks or Snowden. Something's been filed in the court in Virginia, a criminal complaint, but he hasn't been served. And Snowden, we don't know if anything has been secretly filed, but they may. The other thing, by way of introduction, is just that, as your question rightly said, the nature of the secrets involved with the Pentagon Papers, as opposed to a good deal of what Snowden certainly has, some of what he's revealed, and some of the things Assange has revealed, is very great. The Pentagon Papers were a historical study of how the U.S. became involved in Vietnam. Released in 1971, with the most recent document was 1968. And while it had the potential for embarrassment, and I guess the worst you could say in retrospect, it had the potential to lead other countries that were trying to help us get out of the war, Canada and Australia in particular, to embarrass them by the revelations that they were doing this for us and with us secretly. It's nothing, particularly the material Snowden has, and some of the material that Assange has had. So it seems to me they're very different in kind in that respect. The other introductory thing I have to say is the only thing that was decided in the Pentagon Papers case was whether the government could get an injunction, a bar, against the Times publishing. There was no ruling on whether they could be convicted criminally for what they published. And there were some statements and intonations in opinions of judges that voted for them that they might even affirm a conviction under the Espionage Act, even though they wouldn't sign on to the Times not being allowed to continue to publish. All that said, just to say briefly what I do spend some pages on in my book, my own view is that that Assange has behaved with a high level of irresponsibility in what he has published, and my book was written before the information came out about his quite possibly working with the Russians in terms of the release of information designed to harm Hillary Clinton's chances of winning the election, which is certainly something that is suspected. Snowden, to me, is a very different, much harder, and in a way much more interesting case. I think Snowden served the American public in a very real and significant and brave way by revealing the degree of domestic surveillance that was perfectly legal but unknown to the public, and that was going on as a result of legislation and other juridically accepted conduct of the government. I have great qualms about Snowden's revelation of secrets about U.S. intelligence gathering abroad, U.S. spying abroad, U.S. alliances abroad, U.S. listening to telephone of the then president of Russia, of Prime Minister Merkel, of our allied leaders, which I don't think serve the country, and I don't think that someone in Snowden's position, a contract employee, as it were, but a person who had promised not to reveal the very confidential materials that he had access to. My book is critical, very critical, of him for those revelations. Just to offer one example, he describes a previously secret agreement between the U.S. and Norway and Sweden, in which the three countries would work together to engage in surveillance of Russia. The U.S. would fly planes, the Scandinavian countries would gather information, easier for them to gather on a political, social basis about what was going on in Russia. It would all be shared, there would be meetings, there would be discussions, etc. Not a hint of wrongdoing, not a hint that any of the countries, and certainly not ours, had done anything wrong or improper. But it was a secret deal. It's the sort of thing countries do in secret rather than announcing it. That was one of the very, very many revelations. Never a big deal here, but a very big deal in Scandinavia, where the Norwegian government had to explain to its people that they weren't giving the U.S. secret information about citizens of Norway, etc. So, if any of you that read the book will see that my final verdict is quite critical of Snowden for those revelations.
What about the role of the media organs? In the Pentagon Papers days, the New York Times was the Gray Lady. There were 3 or 4 highly respected media organs that dominated the news. But now is there a race to the bottom, and has that affected journalistic ethics or the internal filters?
The New York Times spent 3 months preparing the Pentagon Papers stories. Checked into hotels, took flocks of hotel rooms, had people work in secret, brought in former State Department, former Defense Department, former CIA people to advise them on what they had that could harm national security. The new situation is that more often than not now, it is all but impossible to keep secrets. If for no other reason than that once it's on the internet, it's out. And so, in one way, it has made it easier, albeit still uncomfortable, for journalists at their best, deciding what to print in situations in which if they don't print it, they have every reason to know that it will be printed elsewhere. So what to do when Assange comes calling, as he did, to say, I'd like to give you X about why, you want it or not, because I'd like you to publish it. And generally the answer has been yes. They still engage in editing, but it's not the same. And one of the things we were talking about earlier, and which I advert to in the book, I think if a Snowden had showed up in 1971 at the Washington Post and had said, I've got everything. There's nothing I don't know. I have access to millions of files. I'll give you whatever you want. I think they would have either thrown him out or called the CIA to arrest him. And those days are gone. And we make do. We do get more information now, and sometimes it's very valuable, particularly where there is a level of wrongdoing or even moral ambiguity in the conduct of the U.S. But it sure makes it harder to protect national security as it is defined at the CIA, the NSA, and the like.
So you represented Mitch McConnell in the Citizens United case. So that means that you were on the side of Citizens United, and that's obviously a very controversial case. I'm sure that there's some difference of opinion in this room, but I'm guessing if I polled, most people would think that the Citizens United decision was a bad one. But the Citizens United was part of a progression of cases going back to Buckley against Valeo, a 1976 Berger Court per curiam opinion, which was a pretty garden variety case decision. You want to talk a little bit about the cases and the statutes that led up to Citizens United?
No. Yeah, sure. I will say that Citizens United has helped to bring the country together. There is good polling data, absolutely consistent polling data, that about 80% of the public that are Republicans and 80% of the public that are Democrats think it's a terrible decision. It's one of the few areas in which, on a wholly bipartisan basis, the country has come together. And I was on the other side. Let me say first why, and then I'll do a little bit of the history of it. For me, the idea that when a conservative political group puts together a documentary denouncing Hillary Clinton when she looked like the leading Democratic candidate for the nomination in 2008. Of course, she didn't get the nomination then, but she was the leading Democratic candidate. Here's a documentary from beginning to end, the topic of which is why she should not be president. It was, in my view, a hit job. But political speech about who should be president, no less. And because part of the funding for the organization comes from a corporation, and the organization is itself in corporate form, as is the ACLU and the NRA and all the entities that deal with public issues, it would be a crime under this statute for that film to be shown on television, cable, or satellite within 60 days of the election or 30 days of any primary. For me, that's like I was drafting a hypothetical for a law school class designed to put the First Amendment side in the most favorable light. Political speech, who should be president, an hour-long broadcast, debate of a public nature. My reaction from the start of that case, which is why I became involved, and on a pro bono basis, no less, was that had to be protected. Now, that said, the legal side goes back a few years, as you say, to the 1970s. And it goes back to a time when there was much less money in politics, in which Gene McCarthy, Senator McCarthy, could become involved politically and eventually beat, or just about beat, President Johnson in the New Hampshire primary in 1968, having raised $30,000 from three wealthy $10,000 each contributors. That's what led him, that's what allowed him to participate. And that's what got him involved in this case. Also, on this case called Buckley versus Valeo, Jim Buckley was a Conservative Party candidate in New York State, who later became a senator, a brother of William F. Buckley. And the issue in the case was basically the constitutionality of very strict limits on contributions and expenditures, literally contributions to a candidate, and money spent by the individual or corporation, maybe. And it went to the Supreme Court. And the ultimate decision of the court was to try to split the baby in a way, to say we could limit contributions, because contributions had the potential to corrupt candidates in their behavior and the like. But expenditures, spending money of your own on an election, had to be free from governmental oversight and governmental decision-making, or to add italics to it, from political oversight by political people in the Congress and the like, to pass such a law. And the court, in an opinion, joined as to this issue just about everyone, including people like Justice Brennan and very liberal members of the court, wrote a very strong First Amendment decision saying this is not a role we're prepared to give the government. This is not consistent with the First Amendment. And the court said, if you're telling us that what you want to do is to prevent certain speech of some people who have too much power to equalize the level of speech of everyone, that, they said, is alien to the First Amendment. We don't cut back on speech in order to wind up with less speech in toto. Buckley versus Valeo, from the start, was a very controversial decision, not as much as Citizens United. It could have been read, sometimes it was, to apply to corporations, because one of the parties was the ACLU, which is a corporation. I mean, we should remember when we talk about corporations that most entities that we think of, every university, every bookstore, every concert hall, I don't know about the Aspen Institute, is a corporation. And while one could try to distinguish between not-for-profits and for-profits, that runs into other issues as well. So the Buckley case made its rulings, without getting too deeply into it, but it was viewed as having left open the issue of whether corporations had similar First Amendment rights. There had been a number of cases in the past, and basically cases which really limited union speech under the Taft-Hartley law, which was vetoed by Harry Truman on the grounds that it would violate the First Amendment. And in those cases, the court expressed great concern about the constitutionality of those statutes, but read them very narrowly so that they would be viewed as constitutional. But the more liberal members of the court cited the First Amendment and argued that it was unconstitutional. In any event, along comes Citizens United. By that point, what should I call them? Conservative intellectuals, conservative think tanks had devoted a good deal of time and energy towards trying to persuade the courts that corporations, not-for-profits and for-profit, had First Amendment rights when they talked about politics. And First Amendment, that also commercial, but that's another area. But First Amendment rights to spend money to get their views out. And that was ultimately what the Supreme Court said in Citizens United. Justice Kennedy, writing for the court, said, we've decided 25 cases already in which we said corporations had First Amendment rights. Most of those involved media corporations, sometimes rich, powerful, sometimes one newspaper town corporations. And relying on those cases, and a few which were non-media in nature, Justice Kennedy said that, and the court said, that the speech was protected by the First Amendment, still adhering, and the court and our law still adheres to this distinction between contributions and expenditures. There are limits on what individuals or corporations can contribute to candidates, but there are not limits on what they can spend on their own without giving it to the candidates. Many people think that's a facile distinction or a meaningless distinction now, but that's what the law is. In any event, I don't have to tell you, it's a very controversial decision, and usually I prefer, if I'm asked about it at the end of my presentation rather than the beginning.
Well, we got a home audience too. We want to keep their attention. So, do you think that the repeal of McCain-Feingold and undoing the PACs might have some salutary effect on this? More transparency? Would those things be salutary?
First, I think there should be more transparency, but you should know that the Supreme Court in Citizens United and Buckley affirmed the constitutionality of disclosure requirements. And it was an 8-to-1 vote in the Citizens United case, only Justice Thomas dissenting, saying that the disclosure requirements of the law were constitutional. And so we wind up with the following situation. The overwhelming amount of money that is spent on American political campaigns is from individuals, most of them very wealthy, but not all. Bernie Sanders, you'll recall, talked about how his average contribution was $26. Hillary Clinton talked about over 50% of her contributors, I think, were less than $100, and all that's true. But what is true is that 88% of the money spent in the last campaign and in all of 2016 came from individuals, and about 12% from corporations. This is a major surprise to most of the most strongest opponents of Citizens United, who had predicted that ExxonMobil, could buy Congress out, and their expenditure was zero.
So to be clear, we're talking here about people like the Koch brothers and Soros and the
sure.
Mercers.
You bet.
So these are right and left, powerful and wealthy individuals.
We are the big individual money comes from the people you would think it comes from the Koch brothers and from others, many of whom have made their money from their corporations, but it's not corporate money. It's not treasury funds, as it were, from corporations, and that remains one of the really not well-known realities. We have another problem, which is the disclosure problem. If you go back to 2012, for example, about $4 billion was spent on all federal elections together. Of that, about 300 million is what we refer to as dark money. Money where we do not have a meaningful way at this time to know who or what donated that money or spent it. We know, for example, that the single largest entity in terms of where corporate money goes, where we don't know which corporations, is the Chamber of Commerce. The U.S. Chamber of Commerce, where it's perfectly legal for corporations to donate very, very large sums. The Chamber of Commerce has to say how much they spent and to whom and when, but their members don't. And this is part of a complex law of the really relating to the Internal Revenue Service and the like. But in any event, it was that sort of relationship. I mean, $300 million was a lot of money. I'll bet it was more last 2016, where we are talking about still a small fraction of the money that went into political spending in these years. Last thought, it remains the case that, an individual who doesn't have large funds to contribute is not playing as great a role in the political process as people and corporations that do. I mean, that's That is another part of the reality. That is what the court back in the 1970s, in the Buckley versus Valeo case, was addressing. It's still controversial, the conclusion it reached, but basically saying that that is not a good enough reason to bar people who do have more money from spending it any more than we would bar a newspaper from running editorials every day saying what they think, however rich and powerful the newspapers are. Or to take a better example, if Facebook, which is where most people get their news from now, if Facebook were to start editorializing, it would have enormous impact on the political system. For a variety of reasons, Facebook doesn't, and certainly tries not to, and defends itself. They were accused last year, you may recall, of having algorithms which resulted in a too liberal presentation of views on Facebook. They denied it. I was quoted as saying they had every right to do that. They hated that because the last thing they want people to think is that they're loaded on one or the other side of the political minefield. I mean, they are what they are, and they don't want to be viewed liberal, conservative, sort of just here it is, all of it. Whether someday some administration is going to say Facebook has too much power and we should do something about it is for another audience, another day.
So your view is that Facebook is not a state actor, and Google are not state actors, and are they?
That's not just my view.
Yeah, I understand that, and they're not public utilities.
That's correct.
Okay. Okay. So in the book, you talk a lot about Europe and European rules being different. I think that many people in this room, like me, are very disturbed with the rise of hate speech in this country and how prevalent it has become, particularly in the last election cycle. Our Inclusive America project is actually dealing with just that question. The Europeans have a very different view of hate speech.
Very, very. In part because they have very different histories. But not just that. They also don't have a First Amendment that is read as strongly, as vibrantly as ours is. So when candidate Trump, during the campaign, talked about Muslims and Mexicans, as he did, that speech could be criminal throughout the entirety of Western Europe. I mean, it's fully protected speech here, as is much coarser speech even than that. But that's just not a road we've been willing to go down. And to give one example, which is in the book, in Canada, they had a case just a few years ago in Saskatchewan in which I'd call a religious zealot was so appalled that the high schools there were going to teach about homosexuality, that he printed flyers that he put in every mailbox he could reach, thousands of mailboxes, denouncing the school board and saying, this is all going to be advocacy for buggery. This is all going to be pro-gay propaganda. And he used, the most explicit and offensive and ugly language about gay people and the like. He was found guilty in Canada of engaging in hate speech. The Canadian Supreme Court, Canada has its own First Amendment-like provision. The Canadian Supreme Court said that's perfectly constitutional. The speech attacks a minority. It can mislead people. It can lead to violence. It has no good social purpose. And they affirmed the conviction. Think of that compared to our case involving the Westboro Baptist Church, which, as you may know, is a family which characterizes themselves as a church, and that attends or gets as close as the police will allow them to churches and the like, in which American soldiers who've been killed in Iraq and Afghanistan are being mourned, and they come with signs denouncing the soldiers and saying this is God's punishment, deserved punishment, because we treat gays too well in America. They use the word fags over and over in these enormous placards that they come with. They never come closer than the police let them come. They don't violate a law in that respect. The father of one of the deceased American soldiers brought a lawsuit, and the question was, well, what do we do? Will we allow a recovery in that case? And the Supreme Court, by an 8-1 vote, written by Chief Justice Roberts, joined liberals and conservatives, said this sort of speech is entitled to more than usual protection, special protection, because it's about public policy, gays in the military, how gays ought to be treated, what we ought to think of gay people, and whatever we think, the Chief Justice wrote, whatever we think about the views expressed, this is entitled to the greatest amount of First Amendment protection. That is a view which no other Western country has, in Europe or Canada. And it's just a very recent example of the degree to which we protect speech of a sort that is, very, very hard to accept as part of a democratic process, but which the courts have said that it's very important to protect because of the First Amendment.
So I promised you that we would not get to the current president to the end, because that was going to sort of plunge us down the rabbit hole. So, but now we're going to open it up.
Who is currently in office?
We're going to open it up to questions from the floor in a few minutes, so I thought that we might get in a couple of questions. So what happens when the president blocks people's access to his Twitter account?
That's a new issue. It's clear that the Twitter entity itself is a private entity. The First Amendment doesn't apply, remember, to anything except the government. It has no application to private conduct, private speech, or the like. An employer can dismiss someone because he's a Republican. There are some limits because we have legislation about, racial discrimination, religious, etc. But it's not a First Amendment issue. So if there was an effort to get, Google or whoever to do this or do that by the government, it would fail under the First Amendment. It would fail, I'm sorry, because the First Amendment does not apply in that case. Now here we have a situation which is really unusual. It's the President of the United States. His spokesman has already said it is an official statement, to use the word, that his Twitter comments, it was foolhardy for him to say this, by the way, but it is an official statement of the President of the United States. Now, it's perfectly clear that the United States could not bar access to certain people who want to read statutes or proposed legislation because they don't agree with it. That would violate the First Amendment. So the question here is his Twitter account now the equivalent of a statement of the United, not an entity of the United States, precisely because his people have said it is an official statement of the United States. And so a new foundation, or the Knight Foundation, has funded a wonderful new entity at Columbia University to protect the First Amendment. And one of the first things that they have done is to write a letter just last week saying that this is all official now. You can't, Mr. President, say that people can't have access to your Twitter comments because they disagree with you, any more than the United States could say that this is a statement of the United States, but we'll only let people that agree with it read it on their computers. I think it's a pretty good argument that they have. It's, as I say, it does run into this other proposition which is 100% clear, that a private speaker, Google could say, we don't want right-wing views. We're a liberal entity. That's what we want, and we have a First Amendment right to be that way. That's true. They do have that. But Google US is something else, and what if this becomes a case, will lead to is a very interesting issue about the appropriate characterization of what would have been a private account in the context of it being by the president, and again, I said the foolhardy answer of his representatives saying that it is an official statement of the president. Very interesting matter.
Before we open it up for questions, in the green room, you told me a story about your own connection to the Aspen Institute and to our Justice and Society program. You came to the summer seminar in the Justice Blackmun days. You want to share a reminiscence of that with us?
Yeah, that was a wonderful, wonderful 2 weeks where we started with reading Billy Budd together and spent the better part of a week on Billy Budd, which I had never read before, and it was absolutely fascinating. Justice Blackmun was a wonderful human being who, I think it's fair to say, had been deeply scarred by the level and intensity and ugliness of the criticism of his opinion in Roe versus Wade. I mean, he received fetuses in the mail. He received, just awful. We took a walk one day after a discussion, and I said something truly banal, but something that I meant about the opinion, praising him for the opinion. And I saw a tear going down his face. And believe me, it wasn't because it was me, but the idea that he was being praised for it, and praised on a one-to-one conversation about it, was that meaningful to him. And it occurred at the Aspen conference. Okay, audience questions. Yes, gentleman in the back. I think that is there a mic? Do we have a mic wrangler? Okay. Okay.
Thank you. My name's Steve Miller. The first phrase of the First Amendment regards, in other words, the very first provision of the Bill of Rights regards the establishment of religion. Yes. Does your book discuss that at all? No. The book focuses only really on the 45 words which deal with speech and press. Not because of any other reason,
then that's what I know about. But it does indeed start with religion, and it starts with language, which is a lot more ambiguous, than a lot of other language in the First Amendment and elsewhere. I mean, people can argue about what anything means, but to use the word, Congress will make no law respecting the establishment of religion. The amount of lawyer hours that have gone into arguing about what respecting means. On my part of the First Amendment, we argue about what abridging means. But abridging sounds a lot clearer, if not definitively so.
Yes, this one.
Sir, I was wondering if you have addressed the growing phenomenon of politically correct speech on our campuses and the barring of speakers from one side or another, depending on who's got the majority, I guess, at a time.
Yeah. The book does not address that, for the most part, because that is private campuses are not bound by the First Amendment. Public ones are, but only because it's a different topic. I am testifying next week before a hearing in the Senate Judiciary Committee on that topic, and I have written about it and talked about it on campuses around the country. I think it's a very major problem, and one that is really disturbing. In a way, even more disturbing that the impetus for the suppression of speech comes so often from students now. There was a time when university administrations were the entities that were making political choices, but now rather supine administrations are yielding to students too often who want to suppress speech. Now, some of the situations are ones where there is no blame, in my view, due the administration. Charles Murray at Middlebury College just a month or two ago, who was effectively barred from speaking by students yelling and the like, praised the administration for all they had tried to do to find a place, to protect the place, and the like. But it's a major problem, and just to offer one very broad thought, I can't help but think that we would do better as a society if we taught civics again in our junior high schools and the like. Really, so many students arrive in college without ever having heard almost anything about the existence of the Constitution or the Bill of Rights.
Yeah, gentleman in the back.
Hello, thank you for the talk. A quick question. Now we see a lot of criticism from the media against President Trump, and this is like attack on the press and that kind of lines. But my point is, if the media behave like an opposition party, and you don't see many reporters, doing honest and balanced journalism, but mainly like engaged in the administration as an opposition party, and the president push back, criticize, but don't send anybody to prison, what is the limit there? Thank you.
Well, there appear to be no limits on the president. He has First Amendment rights too. I don't agree with your characterizations of the behavior of the media in general, which I think stems more from the fact that they are more fact-based than the president is. They have, yes, they have been critical of the president, but I don't think they've behaved as an opposition party, and I don't think that his criticism of the press in general and his repetitive statement that virtually any news coverage which he views as negative is therefore fake news. I don't think that's valid. I don't think it's true. But that's the sort of issue as to which people disagree. I read a really interesting article yesterday or the day before asking how would Watergate be covered today, in which the author basically said it would likely be covered as with the Nixon supporters saying this is all fake news. It's not true. None of it's true. Period. But that's my view.
And what are we to make of Kellyanne Conway's statement that there are alternative facts or alternate facts?
Yeah, well, I'm glad she said it.
Yes, the gentleman.
Hi, what's a checklist that an informed citizen should go through when he or she reads about a person in the news accused of leaking to the press? What distinguishes a whistleblower from someone who's giving information out just to give it out?
Well, first, a lot of whistleblowers have ignoble motives. So a lot of them, are doing it just to get it out or to punish the entity they're working in. Some of their revelations are very valuable, nonetheless. I think it's hard to generalize much more than I just have. That said, there are people who view themselves as whistleblowers who have done things which violate the law. And that may well be true of some of the most prominent ones now in the news. We have an ongoing debate which just began with former Director Comey's testimony last week about how to define what we mean by leaking. We used to think at least we knew what a leak was, whether we thought it was good or bad or helpful to the country or not. I don't view it as leaking when a government official who could write a book saying what happened in a conversation he had, which was unclassified by its nature. I don't think that's leaking. But the meaning of words changes. The president uses the word and only uses it in a defamatory fashion. He's a leaker. There are people who have served us well by leaking information. I don't think, a former head of the FBI is leaking when he provides information about which is unclassified and as to which no executive privilege is claimed and which violates no statute, when he reveals what the president said to him and what he said to the president. So I just wouldn't use the word to describe it, but they're like the use of the word fake. We're moving into new territory in terms of our vocabulary and what characterization are fair characterizations of conduct where we know what the conduct is. One can condemn or criticize or praise or be neutral about what Director Comey has revealed, but we know what he has revealed. And we know the position he held, and we know he's no longer there, and we can form our own views about it. I'm just sorry if the nomenclature that is used to describe his act, he's a leaker, blurs the issue of whether we think he has served the public or not.
All right, this gentleman in the front has been very patient. We'll give, and I think that this is the last question.
So last night I read the dissent in Citizen United. Sometimes dissents can be more interesting than the majority opinion, and I would like your views first on the dissent in Citizen United, and when related, in preparing for your argument, there's strengths and weaknesses in any appellate argument, and just curious of what you thought were the weaknesses in your argument, and conversely, the strengths in the other side.
Right. Let me address that first. I thought the strongest argument the government had was one they didn't press enough, which is that there was an enormous amount of testimony in a previous case, which I did argue on behalf of Senator McConnell, and which our side lost a few years before. There was an enormous amount of evidence submitted about the harm that money in politics does, about how much time members of Congress have to spend gathering it, about what contributors expect from it, and the like. I think that's where our opponents, wherever possible, should have been. I was one of two lawyers who argued the case. Ted Olson represented Citizens United. I did not. I represented Senator McConnell as a friend of the court having allowed a lawyer for Senator McCain to appear on the other side, and for Senator McConnell to appear on this side. I made only one argument in the limited time I had. It was really quite clear from the procedural posture of the case. The case had been argued already once, and the court then ordered re-argument, and said it was ordering re-argument on the issue as to whether they should reverse earlier opinions which would have sustained the McCain-Feingold law. So everybody sort of got the point that there were a lot of votes out there ready to vote as they did. This was a 5-4 opinion, as it turned out. So I argued just one thing, which was they should not, that they should write a broad opinion if they thought that the violation of the First Amendment here was one which was pervasive in its nature, repeated in earlier opinions, and which required a rather sweeping articulation of the First Amendment. That is something the court does not do often and seeks to avoid generally. They try to write narrow opinions, leave it to future justices to deal with other issues. But sometimes they think that something is going on which is so destructive of the Constitution as they read it that they really want to write it broadly. So I urged on them that they should look back to other First Amendment opinions in other cases, like the great New York Times versus Sullivan case, which was the great libel decision, 1964, which provided very broad protection for the press. I pointed out that the court could have ruled on a lot of narrower bases in that case, which involved a libel case against the New York Times for an ad, as it happens. seeking money to give to Dr. Martin Luther King and his organizations. He was in prison in Birmingham then. So the sheriff in Birmingham brought a libel suit and won a big judgment in front of an all-white jury in Alabama. The court could have said something wrong with an all-white jury. The court could have said the New York Times doesn't sell enough copies in Alabama to be subject to jurisdiction there. Court could have said the judge was so palpably unfair to the Times that it violated due process of law. And I said to the court that you, different jurists, in a case like that, chose the broadest way to deal with the problem illustrated by the case. And so I argued to them that if in effect, if where you're coming from is that in one way or another, Congress is chipping away at the First Amendment by limiting expenditures by corporations, that you ought to say it broadly. That was the burden of my whole speech. Justice Ginsburg was not persuaded, asked me a series of questions. For example, I was citing this libel case from the 1960s. She said, but in that case, we didn't reverse any opinion of our own, did we? And you're asking us to reverse opinions of our own. And I said, that's true, but you did reverse 150 years of American history in federalizing libel law. And, you know, so we had that out. So that's not a case in which I'm sorry about anything I said, because I didn't have a lot of time anyway. And my motivation in its entirety was a level of reassurance to say to the court, if you want to do this, it's okay. You won't be violating all this body of precedent. So that's what I did. I've had other cases in which I said things closer to alternative facts.
And counsel on the other side of the case, now Supreme Court Justice Elena Kagan, is going to be our guest at the first Sandra Day O'Connor conversation at Aspen on July 10th. For any of you who will be in Aspen, I hope you will join us.
I should say it was her first Supreme Court argument was Citizens United.
And we want to thank Mr. Abrams for being with us. Buy books. He will stay for a few minutes to sign. Thank you so much.
Thank you. Sure.